Good afternoon, morning, or evening. My name is Tiffany Keelas, and today I'll be speaking about the California versus Cabazon Band of Mission Indians case of 1987. The defendants of this case were the Cabazon and Marengo Indians. The Cabazon Band of Mission Indians opened bingo and card game tables on their reservation. The bingo and card games were open to the public. Most of the people that came and played the games were non-Indian. 3 days after opening, the games were shut down by the state of California. The Cabazon Band of Mission Indians argued that the state of California didn't have jurisdiction to shut down their bingo and card games. They argued that the state allowed regulated bingo games in other parts of California. Therefore, the laws that California are trying to enforce on the tribe are regulatory laws and not prohibitory laws. They also argued that the state of California encourages gambling with their state lottery and horse betting. The plaintiff of this case was the state of California. The state of California argued that they did have jurisdiction to shut down their games. The state of California believed that the Organized Crime Control Act of 1970 granted them jurisdiction. The state of California also believed that Public Law 280 gave them jurisdiction as well. The state also referenced Tribal Penal Code Section 326.5. Both defendants and plaintiff referenced several cases to support their claims. One of the laws that was discussed a lot during this case was the Organized Crime Control Act of 1970. The Organized Crime Control Act of 1970 was signed by President Nixon on August 15th of 1970. The Organized Crime Control Act was established to fight organized crime in the United States. As President Nixon said, it would allow law enforcement to launch a total war against organized crime. The state of California argued that the high-stake, unregulated bingo games would invite organized crime. In the court's opinion, the Organized Crime Control Act was said to be federal law. California did not have authority to enforce federal law on the tribal land, because without the Organized Crime Control Act, they would not be able to make the arrests. The courts also believed that if a patrol officer suspected violation of the Organized Crime Control Act, the federal authorities should have been contacted, and they would have determined the next course of action. Another law was Public Law 280. With Public Law 280, some states were granted jurisdiction over criminal offenses committed on or by Indians in Indian country. California was one of the states that was granted jurisdiction. However, in the opinion of the court, it was concluded that the purpose of Public Law 280 was to fight lawlessness on reservations. Although California was granted criminal jurisdiction, the crime must be of criminal nature. In the court's opinion, bingo games were still allowed in other places of California, and the laws being enforced were regulatory laws and not prohibitory laws. The state of California also mentioned the Tribal California Penal Code Section 326.5. The Penal Code doesn't prohibit bingo games, but it regulates bingo games. This law allows the bingo games, but under certain conditions. The Penal Code permits games when they are operated and staffed by designated charitable organizations who may not be paid for their services. The games must not be over $250 and only used for charitable purposes. In the court's opinion, this was a law that regulates bingo and doesn't prohibit bingo. The court ruled in favor of the Cabazon Band of Mission Indians. The courts believed that neither the state nor country had authority to enforce its gambling laws within the reservation. The courts believed the federal benefits outweigh the state's interests. The federal interest was to ensure Indian self-government, which outweighed the state's concern of bingo games attracting organized crime. The goal of the federal government in establishing the Indian Reorganization Act was for Indian reservations to run self-sufficiently. The reservation's games were the sole source of income on the reservation. The courts added that there is nothing in the Organized Crime Control Act indicating that states are to have any part of enforcing federal laws or authorized to make arrests on Indian reservations, that in the absence of the Organized Crime Control Act, they could not. Although the Supreme Court did rule in favor of the Cabazon Band of Mission Indians Act, 3 judges disagreed with the ruling. Justice Stevens announced the dissenting opinions alongside Justice Scalia and Justice O'Connor. They believe that the Organized Crime Control Act allows California to enforce its prohibited laws against commercial gambling on Indian reservations, because Congress has not exempt Indian managed games from state law. Rice Justice even went as far to argue that the tribal bingo games comply with public policy because the state allows driving over 60 miles an hour. It's consistent with public policy because the state allows driving up to 55 miles per hour. Justice Stevens said he was unpersuaded by the court's view. Some cases that were cited by the defendant was the Bryan v. Itasca County case. In this case, the courts ruled in favor of Russell Bryan. Russell Bryan owned a mobile home on the Leech Lake Reservation. The county insists that he paid property taxes, although his mobile home was on a reservation. The courts agreed that Section 1360A granted only jurisdiction over civil causes of action, not broad grant of taxing power. Another case cited by the defendants was the Seminole Tribe of Florida versus Butterworth. During that case, the tribe of Florida ran high-stake bingo games in the state of Florida. However, in the state of Florida, only low-stake games were allowed. The courts ruled in favor of the tribe. The courts agreed that the laws being enforced were not prohibited laws, but regulatory laws. Another case cited was the United States versus Marquez. The Court of Appeals, with that case, established a distinguishment between prohibitory and regulatory laws. In the case, the courts ruled in favor of the United States. They concluded that the law on fireworks were prohibited laws and not regulatory laws. So fireworks were banned. The laws that they were trying to implement were throughout, the whole was a general law. It wasn't just a law that regulates fireworks. Cases cited by the plaintiff was the United States versus Masri case, where a couple owned a bar on their reservation. The couple had a tribal liquor license but didn't get a federal liquor permit. Although they had a tribal license, they still would have been required to get a federal permit because it is federal law. Tribes must still follow federal law. The United States won this case. Another case that was cited, but the court said that they were unpersuaded by this decision, was the Washington v. Confederated Tribe versus Colville Indian Reservation case. This case was a win for Washington State. Washington State argued that cigarettes were sold at a cheaper price without any state tax off of the reservation. Although tribal tax was paid on the reservation, the low cost of cigarettes attracted non-Indians to travel to the reservation to purchase cigarettes, which essentially took business from the state. The tribal Indians were ordered to charge state taxes for non-Indians, meaning that they would normally pay state taxes under normal circumstances. A case that was cited in the descendant argument was the Rice versus Rayner case, where Eva Rayner, a federally licensed trader, had a general store on the Pell Reservation in San Diego. The courts ruled in favor of San Diego. The courts found that Congress authorized state regulation, adding that state regulation didn't interfere with federal policies concerning reservations. A case that later cited the California versus Cabazon case was the Seminole Tribe of Florida versus Florida. A case that laid that the Seminole Tribe sought to sue the state of Florida for violation of the good faith negotiations requirements of the Indian Gaming Regulatory Act. The courts ruled in favor of the state, acknowledging that the California versus Cabazon Mission Indians case gave tribes the right to regulate games on their reservation. However, it did not strip the rights of the states. So the courts agreed that the tribes cannot sue the states in federal court for not negotiating.